Hello, hope you're well. So this is the first topic of legal methods, that is statutory interpretation. Now, for you to be able to discuss what statutory interpretation is, you need to be able to understand the legal framework of statutory interpretation and why it matters. So basically, statutory interpretation means the methodology or the process that court goes through to understand the intention of the drafters of the different laws. So in Ugandan system, you must first give us the legal framework that supports court to make laws, and then go into discussing the different theories and the rules of certain interpretation. Firstly, Article 126 of the Constitution provides that judicial authority is derived from the Constitution and shall be exercised in accordance with the interests and values and the norms of the people. What this means is that every interpretation must be taken as if it should be made with the interest of the people at heart and with the goal of establishing substantive justice. Secondly, when you look at the provision of Article 129 of the Constitution, it establishes that the courts of judicature in Uganda, and it says that judicial authority shall be exercised by courts of judicature in Uganda, to include the Supreme Court, Court of Appeal, High Court, and subordinate courts as like magistrate courts as Parliament by law establishes. Then when you look at Article 137 of the Constitution, it establishes the Constitutional Court and it gives it the mandate to interpret the Constitution. Moreover, you also look at Article 257 that defines acts of Parliament as laws made by Parliament, and Article 79 clause 1 that gives authority to Parliament to make laws, and Article 79 clause 2 that gives Parliament authority to give to other bodies powers to make laws. You must also interpret alongside Article 274 and 275 of the Constitution that say that all laws that existed before the Constitution must be interpreted in line with the Constitution. In other words, they must be interpreted with the necessary modifications to fit the Constitution. Then we can look at the different theories of certain interpretation. Now, in certain interpretation, we have theories of certain interpretation. They are sometimes also called approaches to certain interpretation. Then we also have rules of certain interpretation. And then we have rules of language of certain interpretation. So the theories of certain interpretation, for you to be able to remember them, just know they end with the word "zim." For example, textualism, contextualism, purposivism, intentionalism. Then for rules of certain interpretation, they end with the word rule. Golden rule, mischief rule, literal rule, the whole act rule. Then for rules of language of certain interpretation, those ones are Latin maxims like nocita associs, ejusdem generis, generalia, specialibus non derogant, among others. So basically, when you're interpreting statute, you must follow this. First, let's look at the theories of certain interpretation. The theories of certain interpretation, the main one that we usually focus on is the theory of textualism. Now, textualism looks at the ordinary use of words in their plain ordinary meaning. We look at the text that has been used in the statute and we don't go out of that text. In the case of R versus Judge of City of London, it's an 1892 case. Court held that if the words of court are clear, or of the legislators are clear, then you must give them their plain ordinary meaning, even if they cause an absurdity. Of course, later on, the law has been amended to, the different approaches have been amended that when there's an absurdity, we can bring in another rule to interpret. So secondly, that's textualism. Secondly is contextualism. Contextualism, we look at the context within which the law was actually made. The easiest law that within which we have context in Uganda is the Constitution, the 1995 Constitution of the Republic of Uganda. And the preamble gives us that context. The preamble tells us that we, the people of Uganda, recognizing our history that has been characterized by political instability and tyranny, and determined to create a better future. So they incorporated in the social, the political context, and the historical context to enable us know how to interpret the Constitution of Uganda. So, for contextualism, you look at the political, social, economic, and historical context when they were actually enacting that law. For example, you can rely on the case of Dr. Chiza Besigye versus YKM7 and Electoral Commission, Electoral Petition number 1 of 2001, where a court relied on the preamble of the Constitution to decide not to overturn the elections because they did not want to turn the country back to the situation where it had been. Then we move on to the next theory, which is the theory of intentionalism. Now, intentionalism basically looks at the intent, the specific intent of Parliament when it was enacting the law. You can look at the case of Paper versus Hart. In Paper versus Hart, the case concerned teachers who were being given a benefit because of them not paying tuition for their children on the same school. The question before court was whether this benefit should also be taxed, and whether we should interpret the tax law to cause this absurdity. Court had to seek out to look for the debates of Parliament, or what we call the Hansards, to see what was the intention of the legislators, whether this was something that they intended to encompass within the tax law instead of it being a benefit that is non-taxed. You should look at the case of Paper versus Hart. It's a very good case on intentionalism. The next theory is the theory of purposivism. Now, purposivism looks at the specific purpose of the law. What was the purpose of the law? It's where the mischief rule falls, and looks at, did the law come in place to root out a specific vice? Then you can be able to interpret the law in accordance to that vice that was being rooted out. You can look at the case of Smith versus Hughes, where I think it was the Streets Offences Act that prohibited solicitation along the road. And these prostitutes decided to stand on a balcony and still call or solicit people that were moving across the street. When they were taken to court, they had a defense saying that when we read the literal interpretation and using textualism of the law, the words themselves only prohibit solicitation on the streets. Court looked at what was the vice, what was the purpose of the law that the law was trying to root out, and ruled that the purpose was to prevent solicitation along the streets, and as such, they were liable. So those are the theories. There's another theory that is usually attached on or approach to certain interpretation, which is theological, but this looks at the logical intention of the law, and logically when weighing the pros and cons, what could be the logical interpretation of the law to prevent an absurdity. Usually it goes into the discretion of court to exercise some sort of latitude when interpreting a particular provision of the law. You could read maybe the case of Shaw versus DPP on the gentleman who published magazines that had prostitutes and their phone numbers, and he was charged of an offense that was not prescribed by law, the offense of conspiracy to corrupt public morals. Yeah, they kind of exercise the latitude. In Uganda, this is also permitted under Section 37 of the Education Act and Article 98 of the Civil Procedure Act and also Section 11 of the Magistrate Courts Act. So we move on to the rules of certain interpretation. The rules of certain interpretation include the literal rule, golden rule, mischief rule, whole act rule. Literal rule. Literal rule basically is the same definition as textualism. We look at the words or the text that has been used by the legislators and interpret the words, giving them their ordinary plain language. You can look at URA versus Kajura in Uganda. You can also look at the Constitutional Court decision by Justice Kenneth Kakuru in the case of Malema Bilizi and others, the consolidated petition of 2017, the age limit case. Justice Kenneth Kakuru goes on to discuss theories of statutory interpretation and also the rules of statutory interpretation. But you can also utilize that year one case of Fisher versus Bell, where the gentleman said that when we look at the literal interpretation of the act, it prohibits offering for sale weapons or equipment that can be used as a weapon. The gentleman was displaying a flick knife, and he argued that display of a flick knife is not an offer but a mere invitation to treat. And reading the word per word of the statute, he could not be prohibited from doing that because it was a mere invitation to treat, not an offer, and the law provided for offering for sale. Then we have the golden rule. The golden rule basically states that when you giving the words their plain ordinary meaning is going to cause an absurdity, the court will go back and utilize what is justifiable in the same circumstances. The landmark case along that line is Gray versus Pearson, where a court ruled that the intention of the drafters could not have been to cause an absurdity. So while we are interpreting the their intention, we must be able to also know that they are intending to cause justice. So the golden rule allows you to a symbolism of latitude. The golden rule is the rule that comes from Jesus Christ of treating your neighbor as you wish to be treated. So the judge also asks themselves whether if they were stuck in the same situation, they would be treated in a different way. So then we have the next rule, which is the golden rule. The golden rule basically looks at not the golden rule, sorry, the mischief rule. The mischief rule looks at the vice that Parliament was trying to remedy, or the vice that Parliament was trying to remove from society. The most landmark case of the golden rule was the 1584 Hayden's case. In a Hayden's case, court put up a 4-part test for us to follow to find out what was Parliament trying to remedy. Number one, we look at what was the law before. We look at what is the current law. We look at what was the vice Parliament was trying to remedy, and what remedy did Parliament suggest for us to understand this. You can utilize the same case I gave you of Smith versus Hughes. It's an 1860 case to also look at that. Now, those are the rules of statutory. Oh, I had not talked about the whole act rule. The whole act rule basically says that a statute must be interpreted as a whole, so as no particular section is interpreted to be fighting against the other. For example, one of the best cases that we have in Uganda is the case of URA versus Rabo, where Justice Lillian Tibatem held that the interpretation of Article 139 of the Constitution that provides for unlimited original jurisdiction to the High Court should not be interpreted as to be conflicting with Article 152, which provides for tax tribunals to have jurisdiction for tax matters. That provisions in the same statute are supposed to be complementing each other. That's why we usually have either Section 1 or Section 2 of a particular act to act as the interpretative section for the whole of the act. Yes. So we move on to rules of language. Rules of language are basically Latin maxims that help us to interpret specific words when a list has been given, or to give us context. So the first rule of language is the rule of ejusdem generis. So ejusdem generis basically is a rule of language that says that when a class of items of goods has been listed, and then they use a general word after that list, that general word must be interpreted along within the same class of that has been previously mentioned. For example, if the law says that nobody is allowed to rear lions, tigers, cobras, and other animals, it means that you are going to interpret the word other animals to mean only wild animals. You cannot put in a cow or a goat in the same class. Okay? Yeah. If the law says that, let's say COVID-19 regulation, if it says that nobody is allowed to gather in a playground in any site, including playground, boardrooms, hotels, restaurant, and any other sites. Should we interpret the word any other sites include Facebook sites, WhatsApp sites, because WhatsApp groups, Instagram, or X? No. So that's Educ dem generis. Then we have Nocita Associis. So the rule of Nocita Associis basically means that words derive their meaning from their surroundings. If you have a word minute in between a surrounding of statements that are referring to time, to something that is dealing with time, then you will not interpret the word minute as minute, you will interpret it as minute. Same spelling. It means that you will know, okay, they are talking about time. If we are talking about time, something being small and large, and we use the word minute, you must interpret the word minute as minute, even if it's the same spelling. So we look at the context. Under what context was that word being used? If I came in Parliament and I'm like, members, you are required to sign before you leave. You, maybe a photographer, you cannot come and also sign and maybe be bound by the same provision. Why? Because you, by members, I'm addressing members of Parliament because of the context. So we look at the surrounding words of that word that you're trying to interpret, and that word will get its meaning from whatever has been spoken surrounding it. You can look at the case of Williams versus William. There's Kempton versus Powell. All of those cases can help you discuss Nocita Associis and Educ dem generis. Then the next one is Expressio Unias Este Exclusio Alterius. Expressio Unias Este Exclusio Alterius. What this means is whatever is expressly stated, they impliedly exclude whatever is not stated. Whatever is not expressly stated is impliedly excluded. If Parliament stated expressly something, it impliedly excluded all the other things. That's what they try to mean. So when you look at the case of Tempest versus Cleaner, our court ruled that when Parliament went on to explain when it referred to goods, and then it talked about merchandise and wares, it means that these would not include things like shares. They would not include any other goods that are not tangible, because the list of the things that they mentioned were all tangible things. But also the court ruled that if Parliament goes on to explain something, it is impliedly excluding the rest. Then lastly, we have the rule of certain interpretation of Generalia Specialibus Non Derogant. Generalia Specialibus Non Derogant. What this basically means is that when general provisions collide with specific provisions, the specific provisions take precedent. If general provisions collide with specific provisions, the specific provisions take precedent. Why? Because the legislators went ahead to specify how to deal with that particular area of the law. For example, Justice Lillian Tibatima was faced with the same case in the case of Rabo versus URA. Initially, in Mera Investments Limited versus URA, Justice Kanye Hamba had ruled that the provisions of Article 139 of the Constitution that provide unlimited original jurisdiction of the Constitution carry more superiority than Article 152 of the Constitution that provided tax matters to be listened to by tax tribunals. This was cited as a precedent in the case of URA versus Rabo Enterprises for Justice Lillian Tibatemwa to be bound for. She held that she's not bound by that decision because that decision was held by per incuriam, which means either in ignorance of the law or at least not in the right interpretation of the law. Her argument was that when you use the rule of language of generalia specialibus non derogant, that when general provisions collide with specific provisions, the specific provisions will take precedent. That interpretation would cause us to know that Article 152 that provides for of the Constitution that provides tax matters to be taken to tax tribunals carried more weight than Article 139, which is a general provision providing unlimited original jurisdiction to the High Court in all matters. So those are the rules of language. Lastly, we look at the aids to statutory interpretation. The aids to statutory interpretation are two. We have intrinsic aids and we have extrinsic aids. Intrinsic aids are aids that are within the statute itself that help you to interpret a particular statute. For example, we have the short title. If you see that the short title talks about, it says the Contracts Act Cap 284, it means that everything in that act is going to be related to contract law and should be interpreted alongside contract law. Secondly, when you look at the long title tells you that an act to provide for. The long title is the words that follows the word, the short title. So it says an act to provide for the law regarding contract law, or if it is criminal law, the law regarding criminal law in Uganda and crime and punishment. Then you will know everything is about criminal law within that statute. Yes. Then when you look at the sections and then the subsections also help you interpret, and then the interpretative section helps you interpret, then the schedules and the tables if there are any, and the preamble, like the preamble that we talked about of the Constitution, which gives us context and helped the court in the case of Dr. Chizabesije versus YKM7 and the Electoral Commission, yes, of the one of 2001. Lastly, maybe you need to also be aware of the presumptions that court utilizes when interpreting, which is mainly that Parliament, the presumption that Parliament may not have intended to cause an absurdity when making a legislation. Yes. So that is mainly statutory interpretation. Okay. Now let's look at legal research. So for legal research, basically, I want to look at the different skills for lawyers in legal methods. That is legal research, legal reasoning, and legal writing. For legal research, we look at the process through which lawyers go to actually come up with an answer to a legal problem. That's legal research. So firstly, you need to be aware of what are the key steps for us to find, to do legal research. How do you start and how do you end? And then secondly, you also need to know what types of sources are available to you. So I find it easier for you to first know the types of resources that are available for you before you actually start legal research. So in legal research, we have two sources. We have primary sources and secondary sources. So primary sources, these are laws and cases. Excuse me. These are laws and cases. So in Uganda, we have the Constitution, the 1995 Constitution of the Republic of Uganda as amended. We have different acts of parliament. We have written law, which has acts of parliament and subsidiary legislation. Acts of parliament are laws made by parliament itself, and subsidiary legislation are laws made on the authority of parliament. Article 79, Clause 2 of the Constitution gives parliament powers to delegate their powers to make laws. So these include ordinances, they include regulations by ministries and statutory instruments, among others. Then we cannot apply statutes from UK because the statutes of general application were made no longer applicable in Uganda in the case of Uganda Motors versus Wava Holdings by virtue of the 1967 Judicature Act Amendment. Whereas we retained the doctrines of equity and common law as a source of law in Uganda pursuant to the reception clause of Article 15, Clause 5 of the 1995 Constitution, or over the 1902 Uganda Order in Council, we do not apply their statutes. So after that, under primary sources, we then have cases. So cases are categorized into two. We have Ugandan cases and we have common law cases. Common law cases are used as persuasive authorities to help interpret the different cases principles because they have a more evolved legal system, because our Ugandan legal system is still young and we copy from them. We welcomed common law cases by virtue of Article 15 that I talked about, Clause 2 of the 1902 Order in Council. So those are primary sources. Then we have secondary sources. Secondary sources are things that are outside the law, that explain the law. These include textbooks, dictionaries, journal articles, websites. I understand you guys are going to use Law Teacher, you're going to use LexisNexis, you're going to use ULI, Uganda Legal Information Institute, South African Legal Information Institute, which is SALI, then Bailey, the British and Ireland Legal Information Institute, that have all these cases and some of the summaries of all of these cases. For dictionaries, I would advise to the Blackstone Dictionary. Currently it should be around 13th edition, and then the Merriam-Webster Dictionary. The beauty with the Merriam-Webster Dictionary is it is available online. So yeah, those are the sources of legal research. Then what are the steps of legal research? So the first step of legal research is you understanding the problem. You must understand the legal problem or the legal question that has been posed to you before you actually start legal research. So summarize it and at least extract out what we usually call brief facts. Secondly, you go and consult a secondary source. I know most people want to first consult a primary source, but usually when I understand that a problem question is around murder, the first thing you do is go and find what criminal textbook is available on murder. For example, William Musoke, Criminal Law by William Musoke. When you read his definition of murder, he will tell you that the offense is usually provided for in the Penal Code Act and gives you the section. So you just go to the Penal Code Act, then it will direct you to the primary legislation and the provision that provides for it. Just that our Ugandan law has been amended. We have the 2023 new revised editions, the 7th edition, which means the sections might not be the exact ones, but at least it will refer you to the relevant law, that is the Penal Code Act. Then you can start from there. So yeah, I start with the primary sources, which is the secondary sources, which is the second step. Website, you can Google, and at least you pointed in a certain direction. You can go in a journal article, you can go in the textbook, a dictionary, to point you to the right primary source. Then when you get from the from the secondary source, you go to the primary source that you've been directed to, which helps you formulate an opinion regarding that. Then after getting to the primary source, the law, you go to the case, which has tried to interpret that section for you. For example, Article 139 of the 1995 Constitution that provides for unlimited original jurisdiction of the a high court has been interpreted in cases like URA versus Rabo and Mira Investments versus URA. So we can be able to, if your argument is around that area, you can be able to discuss it. Article 22 of the Constitution has been interpreted by the Supreme Court in the case of Susan Chigula versus Uganda on the right to life and whether the death penalty still exists. So you get the gist on what is court's approach on that particular provision before relying on it. Then the fourth step is for you to note down now all the things you got from your secondary sources and from your primary sources and formulate a legal opinion or a settled position of the law. Then now the next step is you applying that legal position to your brief facts or your legal question. You answer it, you draft in appropriate means of legal writing, and then the next step is get a second opinion from a colleague. The colleague will direct you on where you have misquoted, where you have misfired to panel bit. Then lastly, you can be able to send to your supervisor if you have a supervisor, or if your opinion is directed to a client, then you can be able to make a legal opinion to your client. So that is legal writing. That's legal research, the steps and the different sources of legal research. So next, let's move on to legal writing. Legal writing is basically the legal way of presenting legal opinions and communicating between either lawyer to lawyer, lawyer to client, or lawyer to court. So the different ways in which lawyers communicate. If you're communicating to court, that has been formalized already in the rules of procedure. If you're proceeding in criminal law, you'll proceed by either a charge sheet, or if you're going to the magistrate court, or by way of an indictment and a summary of a case if you're going to the high court. If you're proceeding by way of civil law, which includes contract law, blah blah, you'll proceed by in accordance to the rules of civil procedure on whatever mechanism that has been provided for under the civil procedure rules. They can tell you go by way of chamber summons, go by way of notes of motion, go by way of petition, among others, or go by way of plaint. If you're communicating to a client, usually it's by way of letter or legal memorandum, or legal opinion. If you're communicating to a fellow lawyer, it's usually by way of legal opinion or legal memorandum. A legal memorandum, which is the most common way that we use to communicate as lawyers, should have the title in the middle of the page, legal memorandum, then to who is it going to, then from whom is it going to, then the date on which it has been drafted, and then the subject of the whatever you're trying to submit, and then the introduction or the preamble, the brief facts, the issues, the law applicable, the analysis of each case, of each issue that you raised, then the conclusion, and then the list of references that you've relied on. That's the most normal way, usually, that we render our advice as lawyers and as advocates. Then let's look at principles of legal writing. The principles of legal writing, basically, you must be clear. Clarity. Do not have ambiguous words or statements that can be interpreted in two different ways. That's the first principle, is clarity. The second principle is use of plain language that can easily be understood. Do not overuse vocabularies. Then the second principle is no repetitions. Do not over-repeat yourself, or else people will lose meaning in between your translation. The third principle is do not be verbose. Do not overstate your case. Do not make somebody lose you on track while you are proceeding. So do not use legal jargon. Legal jargon is good, especially when you're submitting to court and maybe to fellow lawyers, but when you're talking to a client or presenting to somebody who is a non-lawyer, please make sure that you prevent using legal jargon, because it will make them, you might lose them along the way. Yeah, then present your document, your legally written document, in using the normal formats, the best formats of legal writing, to prevent the work being unreadable. Have a good font. Usually the academic font is Times New Roman 12, spacing 1.5. If you doing court, usually it's Arial, but anyway, most law firms have what font they choose. But make sure you have good spacing, and the words are readable. So that is legal research. Let's move on to legal reasoning. Legal reasoning is reasoning of judges, the process through which judges go through to make a judgment. So if you understand how the judges make their reasoning, you are able to convince them through your presentation of your work or your case. So we have different forms of legal reasoning, but the most common one is reasoning by analogy. Reasoning by analogy means that the judges will rely on established precedent before making their ruling. That is, they look at previous decisions that have been decided by other judges to come up with a new position. For example, we have the current case of Uganda versus Okello, in which the High Court has sentenced him to death. He has an automatic right to appeal under Article 22 of the Constitution, which says that a death penalty must be confirmed by the Supreme Court. But if counsel for Okello, the defense counsel, decides to make an argument around the death penalty and its illegality, the Supreme Court will be guided by its previous decision in Susan Chibula versus Uganda, which has already settled the position that the death penalty is still a valid penalty in Uganda. Same thing you have looked at when decisions in contract law rely on the case of Karil versus Kabolik Smoke Ball Company, which was decided in the 1800s. Should be around 1893. In criminal cases to date that rely on Wilmington versus DPP of 1935. All of that is reasoning by analogy. You look at previous decisions to make new decisions. Then we have reasoning by discretion. Reasoning by discretion is where now the judge gets out of the box and they reason using their discretion or exercise a certain semblance of latitude. This is permitted by Article 126 of the Constitution, that says that substantive justice shall be rendered without undue regard to technicalities and formalities. Then we also have Section 37 of the Judicature Act that allows court to make a ruling that they seem so fair. The same Section 37 is replicated in Section 98 of the Civil Procedure Act, which also gives them discretion. But also Section 11 of the Magistrate Courts Act does the same for magistrates. So reasoning by discretion, they are given a latitude, which usually people use to justify legal realism and judicial activism. Case for another day. Then we have linguistic reasoning. Linguistic reasoning is where the judges use statutory interpretation, as earlier discussed, to make ruling. They are trying to find a way of interpreting the legislation to understand the intention of the drafters, so as they can make their ruling. Then we have reasoning, inductive reasoning and deductive reasoning. Inductive reasoning is where the judges reason from a specific principle going up to the general principle, and then deductive reasoning is where they reason from the general principle coming from to the specific principle. Let me give you an example. If we are discussing murder, inductive reasoning, when we are starting with a small element moving all our way up, we would start at what are the actions of the accused before and after the crime, which is one of the elements of malice aforethought, and yet malice aforethought is an element of murder. It's an ingredient of the offense of murder generally. Then deductive reasoning would start from up. What are the elements of murder? Malice aforethought, death of a person, unlawful act, and the participation of the accused. Then we go to malice aforethought as a principle under section 174 of the Penal Code Act. And then we look at what are the elements of malice aforethought as explained, for example, in the case of what? Uganda versus Yoweri and Senga, to include the part of the body targeted, the type of murder weapon that has been used, the amount of times that the murder weapon was used, and they accused these actions before and after the crime. So we go from general all the way to down. The best case there would be Uganda versus Lydia Draru, though the conclusion, the judgment, I do not agree with, but that is subject to also your analysis in your criminal law. But yeah, you get the gist. So basically that's legal reasoning, the process through which judges go through when they are coming to make a judgment. Reasoning by analogy, reasoning by discretion, reasoning, linguistic reasoning, then deductive reasoning and inductive reasoning. That is judicial reasoning for you.